Okay, good morning.
Good morning, Your Honors.
Okay. We're here for an oral argument in the case of Magical Cruise Company versus Martins, case 20-379. I'm joined on the panel today by Judge Edwards and Judge Wozniak. These oral arguments are being live streamed so that the public does have an opportunity to view them. Each side will have 20 minutes. I know we have another oral argument scheduled on the same case, if you would, at 10 o'clock, but because of the way Zoom's set up, I think it'd be easier just to do an argument on this case at 9 and do the other argument at 10. So with that, Mr. Ryder, if you wish to proceed.
Thank you, Your Honor. May it please the court. Jack Ryder on behalf of Disney Cruise Line. Your Honor, before I begin, I would like to just confirm, since there's a cross appeal here, I'd like to reserve 8 minutes and then address, unless the court wants me to address some of the cross appeal in my principal argument, I would address both the reply, rebuttal, and cross appeal in my 8-minute rebuttal time.
That's fine. Let me ask the marshal if you could put the clock back to 20 minutes here until we do this. Mr. Anderson, are you going to wish to do a rebuttal argument, if you would, on the cross appeal?
No, Your Honor.
Okay. All right, then go ahead and let you know when it's 8 minutes. And Mr. Anderson, how much time? Well, you're not doing rebuttal, so we're good. Okay, Mr. Ryder, you may proceed.
Thank you, Your Honor. And again, Jack Ryder on behalf of Disney Cruise Line. And of course, Your Honors, we are today appealing with respect to the issue of the punitive damages. And I'll start with the issue of punitive damages. It is our position here, Your Honors, that when the conduct of Disney is examined in a light most favorable to the plaintiff, but under the notion that punitive damages are an exceptional remedy, even in the context of maintenance and cure, here the evidence examined in its entirety demonstrates that there is no reasonable basis to have maintained a punitive damages claim. And Your Honors, when we look at the history here, it appears that neither the trial court nor plaintiff in their response brief really addresses the sliding scale of liability. And in Norwegian Cruise Lines versus Zarino and a host of other cases that we cited for the court, the courts talk about the significance of this sliding scale. The idea that if a jury concludes that maintenance and cure was owed and the ship owner failed to provide it, then the sole remedy would be maintenance and cure. If, after investigating, the ship owner unreasonably rejected the claim, the ship owner becomes liable for compensatory damages.
Mr. Ryder, when you're looking at the sliding scale, can you describe the burden? The plaintiff has the initial burden to show that, okay, I have these doctor bills here, maintenance and cure. Does the burden then shift to the defendant to prove a negative, or does it stay with the plaintiff for level 2 and level 3? And then how does that work with the directed verdict and then also on appeal?
Sure, Your Honor. And it's certainly a bit more complex because of this 3 layers. And I would start from the premise of the plaintiff has the principal burden of demonstrating this entitlement to maintenance and cure. Now, if they show the entitlement to maintenance and cure, then I believe it becomes the burden on the ship owner to demonstrate that the plaintiff had in fact reached maximum medical improvement. Now, I would just stop there for a moment and note that here it is undisputed, and I'll talk about that more in detail, that plaintiff's physicians deemed her to be at maximum medical improvement. But with respect to the burden, I believe, Your Honor, that it is, while there is certainly always going to be deference to the plaintiff's desire for maintenance and cure, or the right to maintenance and cure, I believe that because you've got this shifting kind of burden between the high level necessary to prove punitive damages versus the right to maintenance and cure, I think when it comes to punitive damages, the burden maintains with the plaintiff to demonstrate that the conduct at issue was willful, capricious, arbitrary, and in bad faith. So although there is a deference to the plaintiff with respect to entitlement to maintenance and cure, and we accept the fact that there is deference to the plaintiff and there's this, the burden really of maintenance and cure, once the plaintiff presents a basis for maintenance and cure, they're subject to certain exceptions, which I'm also going to describe. There is certainly this entitlement. However, when it comes to this high level of demonstrating arbitrary and capriciousness, I believe that that burden should stay with the plaintiff, even when examining all inferences in a light most favorable to the plaintiff on a directed verdict. And here, I would submit that there is nothing here, nothing, that rises to the level of conduct that is, quote, callous and recalcitrant, arbitrary and capricious, willful, callous, and persistent. And when courts describe punitive damages, for example, we've cited Atlantic Soundings, talking about it being available in, quote, exceptional circumstances, such as willful failure to furnish maintenance and cure to a seaman. Courts describe that high level of conduct, again, as utter disregard for consequences, shocking conduct, and criminal indifference. Here,
Mr. Ryder, let me ask you as a follow-up to Judge Wozniak's question, whether recommended treatment is curative or whether it's just designed to alleviate pain. What's the respective, or what are the burdens of proof there?
well, Your Honor, I would submit the burdens don't change. In other words, it is well settled that once a plaintiff reaches maximum medical improvement, the burden to provide maintenance and cure does not apply to curative or palliative care. And we've cited a host of cases that are very clear about that. So I would submit that once two of plaintiff's physicians that she selected designated her as having reached maximum medical improvement, the burden stopped. And to the extent that there was an ongoing burden with respect to, and again, claims for curative, palliative, those items are not covered under maintenance and cure once the plaintiff reached maximum medical improvement. And the case law on that is quite uniform, Your Honor. And with respect to the burden, again, I still maintain that it remains the burden of the plaintiff to demonstrate that the conduct at issue in not outright denial of further maintenance and cure, but in continuing investigation, in continuing communication, in continuing evaluation, should rest with the plaintiff. However, I would say this, even if the court concluded that it was Disney's burden to show that its conduct was not willful, capricious, and in bad faith, I would submit that we absolutely proved that as a matter of law based on the totality of evidence, and this should never have reached a jury on the question of punitive damages. And that's why I think, Your Honor, the sliding scale is so important, because we are not even challenging whether or not Disney was, quote, unreasonable, unquote, in denying maintenance and cure. So I would submit that, and we're not challenging unreasonableness finding, but with willful, capricious, bad faith, and that sort of conduct, that simply doesn't apply here. And if we look at, again, the history, the chronology is so important. Plaintiff selected her own physicians at her choice. She went back to her home country. She wanted to choose Dr. Atade. She wanted to go to Dr. Rivera. Disney paid every medical bill without question. Disney advised her, the plaintiff, that she could see as many physicians as she wanted. And in Rodriguez versus Bahama Cruise Line, the court held that a seaman has the right to select the physician of their choice. That was repeated in Turner versus Inland Tugs Company, where it was a ship owner was found to have acted in bad faith when it denied a plaintiff the right to pursue a physician of the plaintiff's own selection. And here, going back to the chronology, Disney provided maintenance and cure for 7 months until she was deemed to be at MMI. Then Disney provided maintenance and cure for an additional 3 months after the second disembarkation, once again until another physician deemed plaintiff to be at maximum medical improvement. And so here, when the plaintiff, and I think it's important to note here that when the plaintiff first came back to Disney and demanded to be compensated, after her maintenance and cure had been paid for months and months and months, it was back on October 1st, 2014, and this is at the record at 3880, where the plaintiff wrote to Disney and said, quote, even though technically I've reached the point where my medical situation will not improve, it does not imply that I've recovered. Now, the plaintiff knew that she had reached maximum medical improvement because her physicians had told her so. She was looking for more money because she claimed that she had been injured as a result of negligence by the shipboard doctors. But that's a very different claim than the issue of maintenance and cure and this notion of punitive damages.
But moving down the chronological line, and I guess it's after the suit was filed and there were medical records going from Miss Martin's counsel to Disney's claims department, was it enough that Disney's claims manager and I guess the legal department were reviewing the records, and Disney, I saw from the record, correct me if I'm wrong, but did not hire a doctor at that time to review the records? It wasn't until a couple years into the lawsuit that a doctor was actually hired to look at the records and did agree that MMI had previously been reached. But is that enough for Disney to have acted reasonably?
First of all, Your Honor, absolutely it was enough. But I also want to just fill in a few points on the chronology, if I may. Your Honor is correct that Disney did not have a physician right away, but there's a couple of important caveats to that point. First of all, Dr. Ribeiro's declaration, the plaintiff filed suit and then came up with a new declaration from Dr. Ribeiro. The Dr. Ribeiro declaration, which was in July 2017, was 3 years after he had declared plaintiff to be at MMI and 1.5 years after Disney was sued by the plaintiff. So we have here, 3 years later, a new declaration. And what's important about the Dr. Ribeiro declaration, and this comes through not only through his declaration, but through his affidavit and through testimony that we also heard from Dr. Pita, that Dr. Ribeiro never disavowed or retreated from his prior finding that plaintiff was at maximum medical improvement for the intercostal neuralgia that he had asserted was the only injury that resulted from the accident at that time. So when we talk about the chronology, Your Honor, it's important, I would submit, to note that Dr. Ribeiro, while they've submitted these additional reports, neither Dr. Ribeiro nor Dr. Atade had ever disavowed the prior declaration of MMI. So when Disney and its counsel reviewed these documents and noted that, it's true that they didn't immediately hire an outside physician to examine it, but they also reviewed the documents. And if we look at the ultimate result, Dr. Herskowitz, who Disney did retain, reviewed the materials, confirmed through his testimony that there was no disavowing or receding from the prior declaration of MMI. And again, more importantly, I would submit, is that when Dr. Pita was called upon to testify, Dr. Pita said that he wasn't challenging or receding or in any way undermining Dr. Ribeiro's finding of MMI that had been reached several years ago. So,
Counsel, is the ship owner entitled to rely upon the Siemens doctors in terms of maximum medical cure and with regard to whether treatment is curative or palliative?
Absolutely, Your Honor, in the sense that this, and what I would submit, I have not seen a case from opposing counsel in their brief. I have not seen a case where a ship owner relies upon the Siemens doctor who has deemed the seaman to be at MMI, and that the ship owner is then found to have acted in bad faith for not accepting the Siemens' own physician. So, you know, the cases that we see that I've reviewed and that counsel for the plaintiff cites to, these cases, there's a lot of contradictions. There's a conflict. The plaintiff's physician says there's no MMI, and the ship owner hires a doctor or doesn't even hire a doctor and disputes the finding. You know, we see those kinds of circumstances where there's a conflict. But this is a case where we've got not one, but two of the plaintiff's own doctors taking this position and never retreating from it. So on this issue of maximum medical improvement, I believe the ship owner has an obligation to defer to the plaintiff's physicians, because certainly if the plaintiff's own doctor reaches this conclusion as a matter of medical evaluation, then I think it would be inappropriate for the ship owner to contradict that.
Mr.
And
Martin,
Do you want to talk about Anderson at all, or because
Yeah,
you're getting
so-
into your rebuttal time?
I do, Your Honor, but I think it's, I obviously, you know, our brief lays it all out, but I think it's important to note, we are not just asking for the punitive damages to be vacated, but I submit here that a new trial is also appropriate. If we look at the plaintiff's counsel's closing comments, Your Honor, the comments from counsel were really egregious. And
Mr. Martin, let me stop you there, because I do want you to address Anderson and what Anderson would, if you're correct on that, what that would do as far as a new trial.
Yes, Your Honor. Well, with respect to yes, Your Honor, with respect to Dr. Anderson, or Mr. Anderson, I should say, who's an economist, Mr. Anderson testified regarding future medical expenses of $1,664,969 and lost future wages of $1.3 million.
Maybe if I can cut to the chase a little bit, counsel.
Yes.
Assume we agree with you that Dr. Anderson should not have been allowed to give opinions on future medicals because he didn't have a sound basis. Just use that assumption. With the way the verdict form lumps together all economic damages past and future, how do we find that there's, how do we figure out what the error is there? And given the verdict form, would the ship owner be entitled to a new trial?
We are entitled to a new trial under two theories, Your Honor. First of all, the court can evaluate based upon examination of what the improper testimony was. If you look at the future lost earning capacity and future medicals, the court can extrapolate out that there are, Mr. Anderson testified as a $215,400.
Mr. Ryder, you got these super round numbers. It's one thing when you've got future medicals of, 10,050 and you see that on the verdict form somehow. It's easy to back that out, but with these round numbers, it's kind of makes me scratch my head a bit.
Your Honor, I think here, the way we carved it out in the brief demonstrates that there's 1 million, it's not round, it's $1,777,892 in future economic damages, which the court should not allow to stand. So in other words, should the court decide, although again, I submit we're entitled to a new trial entirety, or at a minimum, the punitive damages be vacated, with respect to Mr. Anderson, we've cited Eagle versus Maglio, where the verdict could not distinguish between medical expenses and wages. It was appropriate to consider the maximum amount of medical expenses supported by the evidence and assume that the remainder was for loss of earning capacity. So in other words, the court can look at what was the appropriate lost wages that Anderson was authorized to testify to, and then back its way out to the fact that $1,777,892 is completely unsupported by this record. And so that piece, Your Honors, could be vacated on a reversal and remand, and should be.
Your 5 minutes. Do you wish to reserve? Okay, thank you.
Thank you, Your
Mr.
Honor.
Anderson.
Good morning, Your Honor. My name is Ralph Anderson, and I'm here on behalf of the appellee cross appellant, Ms. Martins. And I just advised the court, trial counsel Julio Ayala is present in the room with me. First of all, as to the directed verdict argument, I'd like to, in a sense, this is beginning at the beginning. The only maximum medical improvement MMI declaration involved in this case is the second one from Dr. Ribeiro in July 2014. There has never been an issue as to the initial MMI in April or March of 2014 from Dr. Hatade that had to do with fractured ribs. Ms. Martins went back to work, then was diagnosed by Disney's own doctors as having intercostal neuralgia, which is a different medical animal than the fractured ribs. It's the sequela of fractured ribs. So the only MMI that is of concern to this court is the second one of Dr. Ribeiro in July 2014. Now, it's important to remember here, Your Honor, that Dr. Ribeiro is a neurosurgeon. Dr. Ribeiro is not a neurologist.
Okay, let me ask you about that, counsel. Disney, when she was on board, told her she needed to see a neurologist. They were supposed to set one up in Port Canaveral. Somehow that didn't happen. But then her own doctor, Dr. Biscaya, I'm not sure if that's exactly right, but you know who I'm talking about. Her own doctor then recommended that she see a neurologist. So she's got two doctors telling her to see a neurologist. She then chooses to see a neurosurgeon. I'm struggling with how that's Disney's fault.
Well, Your Honor, first of all, Disney, I know Disney tries to make it sound as if Ms. Martins here insisted that she see Dr. Ribeiro instead of anybody that Disney would have recommended. That is not how this occurred. First, I'd like to point out, and we cited a supplemental authority, Your Honor, the Caboro case from the 11th Circuit, which expressly recognizes that to satisfy ship owners' maintenance and cure obligations, ship owners routinely select the doctors to be treating the patient.
You're not answering my question. She was told by two different doctors, one from Disney, one of her own choosing, to see a neurologist. She chose to see a neurosurgeon, and you act like that's Disney's fault somehow. And that's what I don't understand.
Now, here, I'm sorry if I gave you that impression, Judge. The maintenance and cure obligation implies or requires more than simply paying for medical treatment. It also implies that you need, the ship owner needs to make sure that the medical treatment is appropriate. Now, we've cited cases to that effect. Now, in this case.
What more could Disney do if they recommend a neurologist and then she goes to neurosurgeon, the neurosurgeon does report? Are they supposed to tell her you went to the wrong type of doctor and we reject the view of your doctor?
No, Your Honor, what we think is that Disney had an obligation under the maintenance and cure rule, which, like I said, requires more than simple payment. They had an obligation to tell her that she is reviewing, has gone to the wrong specialty. What happened here is that.
What case says that? What case says that?
The case that we cite is the Dos Santos versus Ajax, or maybe it's Ajax versus Dos Santos. And what that says is that to comply with, excuse me, I'm sorry. Well, it eludes me here. What it says is that there's more, the obligation of the ship owner is not simply to pay for the maintenance and cure. It is to ensure that the maintenance and cure is appropriate.
But then Ms. Vendrell sent her letters and they were in constant contact about, here's what your rights are, here's how you do maintenance and cure. She never seemed to have any questions about it. I mean, again, if Disney and her own doctor told her to see an orthopedist and she chose to see a chiropractor, which you see all the time in personal injury cases, you know, she'd rather go to a chiropractor instead of an orthopedist. She'd rather go to a neurosurgeon instead of a neurologist. I mean, what's Disney's obligation at that point?
We think that Disney's obligation was to inform her that she had chosen the wrong medical specialty. She did not know the difference between a neurosurgeon and a neurologist. That's apparent throughout the record. And
Does that mean
the
first doctor
record?
was also unaware of the difference between a neurosurgeon and a neurologist?
I'm sorry, Judge Edward, could you please?
The referring doctor, does that mean he was also unaware of the difference between a neurosurgeon and a neurologist? Because he also.
No, I'm not saying that. The referring doctor said go to a neurologist, but she did not. She went to a neurosurgeon, obviously by mistake. Now, the thing is that.
What evidence is there if Disney had said you're going to the wrong doctor after two other doctors had told her who to go see, that she would have gone, oh, geez, thanks, Ms. Vendrell. Now I know who to go see.
Well, I think Ms. Martin's testimony in this case is that the only reason she did go out to see a doctor is because Disney refused to select one for her, which, like I said before, in the Cavoro case, ship owners routinely selected doctors for their injured seamen. She went to the wrong specialty. Magda Vendrell, the corporate rep for Disney, expressly stated that she knew that Ms. Martins was supposed to see a neurologist, not a neurosurgeon. She knew that Dr. Ribeiro was a neurosurgeon and not a neurologist, and she nonetheless did nothing about it. And when she saw the MMI, here's another thing. The MMI was from a neurosurgical point of view, and we have from a neurosurgical point of view. And what's interesting is that my opponent was talking a few moments ago about how Disney had the right to rely on Ms. Martin's treating physician in this case, and to not allow reinstatement of maintenance and cure. Well, the problem with that argument, Your Honors, is that Dr. Ribeiro submitted more than just a declaration or a certificate. Dr. Ribeiro also submitted an affidavit in which he said that the MMI declaration of July 2014 was solely for the diagnosis of intercostal neuralgia, not any of the other conditions that Ms. Martins has directly related to that accident. He also said that his MMI declaration was strictly from a neurosurgical point of view, and that he would defer to pain management doctors,
Mr. Anderson, let me ask you this. Going back to the neurosurgeon versus neurologist, would you agree that Disney's representative would not be aware that if, there would have been a different result if your client had gone to a neurologist rather than a neurosurgeon?
Well, I'm not really sure about that, Trent, but I do know.
The reason I'm asking that is,
She understood the distinction.
even assuming that Disney should have said, hey, you went to a neurosurgeon, you should have gone to a neurologist, is that negligence or is that bad faith justifying punitive damages?
Well, we think it's just one more block in the chain of bad faith, or at least willful and arbitrary misconduct. She knew that the wrong medical specialty had been consulted. She knew it right from the get-go. She was paying the bills. She said she knew it, and she said, I didn't contact Dr. Ribeiro, and I didn't contact Maria to inform them that this is the specialty that was unlike the one that was recommended before. She also testified that they subsequently got all these medical records, including medical records from a neurologist, her treating neurologist, Dr. Pita, and the treating neurologist in this case says, A, Maria or Ms. Martins is not at MMI. B, she's suffering from cervical radiculopathy and compressed vertebral fractures from T3 through T5. And all of this was related to the car accident which started this whole lawsuit. And he also said that she was not at MMI.
When was the date? When was the date of the first medical record that specifically stated a causal relationship with the new symptoms? When was that date first?
I believe that date was in August of 2016, Your Honor. And
That was 2 years after Dr. Ribeiro's MMI, correct? Because that was
2 years after the MMI, but I would like to at least point out that as soon as Disney discontinued maintenance and cure, or cut off maintenance and cure in August of 2014, based on Dr. Ribeiro's MMI, limited MMI after intercostal neuralgia, Maria, Ms. Martins, I apologize for that. Ms. Martins immediately contacted Ms. Vondrell and testified that she said, please do not discontinue my maintenance and cure. I still need maintenance and cure. I am suffering the pain, etc., and I've never even been treated for it. And she actually mentioned that this was from a neurosurgeon and not a neurologist.
Mr. Anderson, I want to ask you, like I asked Mr. Ryder, about the burden and whether there's a burden shift with the level 2 and level 3. Do you agree with Mr. Ryder's view about the burden, and if not, tell us why?
Well, Your Honor, we believe, and I think the case law supports this, is that, well, I know the case law supports this, and my opponent disputes this, at least in their reply brief, and that is in the entire punitive damages analysis, the Vaughn rule, which is the Vaughn versus Atkinson seminal Supreme Court decision, that rule says that when considering whether or not to discontinue or not reinstate maintenance and cure, the ship owner is legally required to resolve all ambiguities and doubts in favor of the seaman. That's the Vaughn rule. Now, we have cited cases that show that the Vaughn rule also applies in the punitive damages analysis. And that's the Breeze case, which is cited, I believe, in both briefs, and the Wolf case. Now, when you have the Vaughn rule applied under the circumstances of this case, we find that for sure, at least our opinion, that the investigation here was lax. Laxness in investigation is grounds for a punitive damage award. We've cited the cases for that. In addition, another ground for punitive damages is when there is a new condition that presents itself and the ship owner fails to reinstate maintenance and cure. Well, we have that here, we believe, in spades. We've got the cervical radiculopathy, we've got 3 compressed vertebrae. all of which are attributed to this very accident. We have a MMI, a doctor, the treating neurologist, who says that there is no MMI here. And nonetheless, Disney refuses to reinstate maintenance and cure.
I have a question, counsel. I have a question for you. In terms of Dr. Pita, when he said she wasn't at MMI, he checked off the box for palliative care. I mean, what?
Well, that was.
What do we do with that?
Well, first of all, Your Honor, viewing the evidence in the light most favorable to us, Dr. Pita submitted a crew medical status report in I believe it was in early 2017. And this crew medical status report shows that the diagnosis is vertebral collapse, D3, D4, D5, and sternal fracture, which I'll talk about that in a moment. And then it says treatment recommended, curative treatment recommended, pain clinic and rehabilitation. And then it says maximum medical improvement, and he answers no. That's signed by Maria's treating neurologist. And during his deposition, when you look at the questioning, he talked about the type of treatment, the pain medicine, pain management, and also talked about the physical therapy. And he made the point that these types of treatments would better Maria or Ms. Martin's physical condition. That is the definition of curative treatment. As a matter of fact, if you look at that crew medical status, if you look at the actual MMI declaration that Dr. Rivero filled out in his neurosurgery capacity and solely having to do with intercostal neuralgia, the definition of maximum improvement is that where it appears, let's see, is otherwise improve the seaman's physical condition. That is curative treatment. That's exactly what Dr. Pita testified to during his deposition, which mirrors what was stated in the crew medical status report, which was forwarded to Disney.
Mr. Anderson, let me have you address two other matters. One is the testimony of Mr. Anderson, and I want you to assume that it's, as far as future medical expenses, he may not have had a sufficient basis. Just assume that. What does that do as far as the verdict or the request for new trial, given that the damages for economic losses were all grouped together, future and past, lost wages, medical, and then also if you could address the your cross appeal issue.
Well, Your Honor, given my time constraints as to the cross appeal, we will just rest on our brief.
Okay.
However, as to Dr. Anderson, at the risk of being non-responsive, before I get to your question, Judge, I would like to at least make the point, not at least, we believe that there was no abuse of discretion here on the part of the trial judge in permitting Dr. Anderson's testimony. And there's several reasons for that. And perhaps the biggest one is that this argument, the argument that my opponent raised in their initial brief and then in their reply brief, for the most part, it was absolutely waived. The motion to strike.
Okay, let's assume on the reasonable medical certainty was waived. How about the part that he didn't have sufficient evidence as far as the frequency of treatment? The frequency of the recommended treatments.
As to that, Your Honor, we think that the judge got it right, saying that this is a matter for a matter of credibility and cross-examination. And the verdict here shows exactly that Judge Majid was right all along. What Dr. Anderson testified to was $3,200,000 in future economic damages. What the jury awarded here was $2 million in economic damages. which means that the jury discounted Dr. Anderson's testimony by 39%. Throughout all of Dr. Anderson's testimony, you won't see an objection.
We don't know what they discounted, whether they discounted on future wages or on future medical or on past medical or on past wages. And we don't know what they discounted.
Well, no, you're correct. We don't know. So at bottom line, I guess your question is, what's the result? If you are inclined to find that no reasonable person could have done what the trial judge did here, which is the standard for abuse of discretion. If you find that, then if there's going to be a new trial should be on economic damages alone, without any, as to any of the other issues, but not without carving it out, because like Your Honor pointed out, it's not itemized on the verdict form. But
Let me ask you this,
obviously,
the testimony of Mr. Anderson was based on Miami prices, medical expenses. Is that correct?
Yes, it was, but there was no objection, as far as I can recall, as to that issue. This entire Anderson point, respectfully, for the most part, is an appellate afterthought, or it certainly wasn't brought up during the trial.
Okay.
During the trial, I see that I'm running out of time here, so I would respectfully request that the court uphold the trial judge's decision to deny the directed verdict on punitive damages. And even if that the court disagrees with that, there's no need for a new trial on all issues for the reasons that we set forth in our brief. And we also believe that the trial judge did not abuse his discretion regarding Dr. Anderson's testimony.
All right, thank you, sir. All right, Mr. Ryder, rebuttal, you have 4 minutes and 55 seconds left.
Thank you, Your Honors. So with respect to this issue of Dr. Pita, and the first thing I would note about the Dr. Pita diagnosis is that it was years after the declaration of maximum medical improvement, years into litigation, and there was never a recession from or a disavowalment of the prior declaration of maximum medical improvement. And I think that in and of itself is critical, because this notion that the plaintiff can file their lawsuit and then years into litigation bring a new physician, whether it's a retained expert or a treating physician, and say, well, now we've got a new document and it's and it says that the person is no longer at maximum medical improvement, and raises brand new injuries that had never before been identified by any of the prior physicians or the medical centers, or whether it was the hospitals that plaintiff had gone to, or Dr. Atade or Dr. Ribeiro or other physicians. Disney had a right at that time to inquire further and to investigate. In Bourgeois versus Transocean Deepwater, the court explained that a ship owner has the right to investigate a claim for maintenance and cure before tendering any payments, without subjecting itself to liability for compensatory or punitive damages. So, and there's many cases like that. M&M Boats versus Johnson. A failure to pay maintenance and cure is reasonable if a diligent investigation indicates that the seaman's claim is not legitimate. And the court there held, this is the Fifth Circuit, we refuse to adopt the rule, which is that anytime there is a dispute among physicians concerning the employee's condition, any termination of maintenance and cure by an employer is per se unreasonable or egregious. Here, there is a litany of documents that we cited, record 3757, 3772. We've cited them throughout, the correspondence in the back and forth, where there was an ongoing intent to investigate. And once again, as Judge Edwards and Judge Evander, you pointed out, what more was Disney going to do when it advised the plaintiff to seek treatment? The plaintiff returned to her home country. Disney continued to pay the medical bills. And as you noted, the plaintiff was told to see a neurologist. She testified that she selected Dr. Ribeiro based upon a recommendation from a neighbor or friend. So this is somebody she sought out based on a recommendation. And it wasn't Disney's place to second guess the plaintiff's choice about who she chose, and there's been no suggestion that Dr. Ribeiro was unqualified to do what he did. And Your Honors, with respect to this issue, and I stand on the point that it would be respectfully, based on the litany of cases we've cited that highlight the kind of conduct that rises to the level of punitive damages here, to look at those cases without going through the detailed facts and juxtapose them to the conduct at issue in this case, I believe that as a matter of law, the judge should have directed the verdict on punitive damages. And I emphasized during my initial presentation that I honed in on the closing comments because I think it's important to note that the comments that were made by counsel respectfully were fairly egregious. And I understand that counsel put them forth and sort of defended them at the time when there was an objection posed based on the fact that there was this punitive damages claim in effect. And the reason why that's so critical, Your Honors, is because I don't believe this verdict can stand in its entirety. But once again, at a minimum, the punitive
Counsel, did Disney move to bifurcate the punitive damages issue? In other words, in punitive damages cases, often you have compensatory and allocation of liability for punitive damages in phase one. If the jury finds punitive damages are in order, phase two, they do the amount. And doing it that way, that's when all the financial information and the fiery arguments come in. Did Disney move to bifurcate?
Your Honor, I don't know that there was a motion to bifurcate. There was at least 4 different challenges to the punitive damages. There was a motion in limine to preclude evidence of punitive damages, which I would submit is the functional equivalent for what Your Honor is referring to. And going back to maintenance and cure, once the judge allowed the punitive damages to come into play, the plaintiff used that as a wide open doorway to really impugn the integrity of Disney as a company. And we've set forth the comments in our brief, Your Honor. With respect to Dr. Anderson, if the court does conclude that, in fact, and I would submit that his testimony was unsupported by McKenzie and the idea of these future medicals and lost earning capacity, then I heard counsel suggest that there should be an entirely new trial on the economics. Well, I would submit that that's a possible remedy. If there's a new trial, it would be without punitive damages and without these economic future lost wages. And of course, at this point, Your Honor, I'm into the end of my time. Since counsel didn't argue anything with respect to his cross appeal, then we will also rely on our brief for that issue. Unless there are any
Thank
questions.
you both. We'll see you gentlemen in about 18 minutes.
Thank you, Your Honor.